Is there a way to get a quick decision in a workers' compensation case if there is an emergency? Hi, my name is Zach Anderson. I'm an attorney and co-owner at 217 Law, and I help injured workers across central Illinois. So the Illinois Workers' Compensation Act does have what are called 19B hearings. Under 19B, the arbitrator assigned to the case, it's supposed to render a decision as to a disputed issue within 180 days after a 19B petition is filed. A 19B hearing is typically used when medical benefits or temporary total disability benefits are in dispute, and either the employee or, in certain situations, the employer uh, may request a 19B hearing, although in practice, it's typically the employee who files a 19B petition. There are some limitations to 19B. Um, the easiest way of thinking about it probably is that some issues that an injured worker may think is an emergency do not qualify as emergency issues under 19B. For example, if there is a small amount of disputed TTD payments, temporary total disability payments, but the employee has already returned back to work, then a 19B hearing may not be available, even if the injured worker considers their unpaid TTD to constitute an emergency. There's another emergency process called 19B1. This 19B1 petitions are more rare than 19B petitions and the regular 19B petitions. There are a lot of technical requirements that must be followed before a 19B1 petition can even be heard. And then after an emergency issue is decided on a claim, that rarely resolves the entire claim. And so the case is then returned back to the call or the regular arbitration schedule. And then any outstanding disputes, such as permanent disability, will then be decided at a later date. If you have any questions about emergency hearings under the Illinois Workers' Compensation Act or work injuries in Illinois in general, please feel free to reach out. Be happy to talk to you.